2022 CR 9877, State of Texas versus Francisco Hostel. Staff parties announced for the record.
Yes,
The state.
Travis Rodriguez for the state of Texas.
Defense. And are you Mr. Hostel?
Francisco Medina Hasso.
Is that who you are?
Yes. Yes.
And we have an interpreter here. Could you raise your right hand for me, please? Do you solemnly, not you, sir. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you may lower your hand. Could you state your name for the record?
Vicky Cavazos Jones.
Counsel, do you speak Spanish?
I do.
And do you speak it fluently?
My first time. Very fluent.
And have you been able to review all of these documents with your client in Spanish?
Yes, I have.
Mr. Hasso, all of the documents that we're going to discuss are in English. Were those documents reviewed with you in Spanish?
Yes.
And did you understand those documents?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Hasso, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state moves to proceed on count 3 of the indictment. That is a third-degree felony, and waive and abandon the remaining counts.
Any objection? Mr. Hasso, did you review the document with your attorney entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions?
Yes.
Did you understand in count 3, you're charged with the offense of possession of, that's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes. Yes.
Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow that plea bargain agreement? If for any reason the court does not follow that agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was mentally sane at the time of the offense?
Yes.
Mr. Hasso, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, were you aware that your client is not a U.S. citizen?
Yes.
Has he had a chance to review this plea with an immigration attorney, or did you advise him?
I advise you.
Mr. Hasso, has your client informed you of the immigration consequences of entering a plea in this case?
Yes.
Did those consequences include deportation,
The prosecution narrows the case down to count 3 and drops the remaining counts. Now the defendant is facing one specific charge under this plea agreement. But the real question is what rights he is giving up to take this deal.
the denial of naturalization, and not being able to re-enter the United States.
Yes.
Did you understand the consequences of entering a plea in this cause number as it relates to your immigration status?
Yes.
And knowing those consequences, do you still wish to go forward with the plea?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. According to the plea bargain agreement, state is proceeding on count 3. Punishment is to be assessed at 4 years in the prison. There are no applications. The state is taking in consideration the following cause numbers: night bag number 671041, 671043, 671040, CM number 101289, and there's lifetime registration. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes.
State, is that the plea?
It is the state's understanding, Your Honor.
Did you review the paragraph with your attorney entitled waiver of appeal paragraph? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes.
Counsel, have there been any such motions?
There have been no motions.
Then Mr. Hasso, to count 3, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. The state has previously tendered States Exhibits 1 and their attachments to opposing counsel. At this time, the state offers States Exhibit 1 and attachments to the court pending any objections.
Without objection.
Mr. Hasso, did you review the documents entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Strong.
Anything you wish to say on behalf of your client?
Yes, sir.
Court will sentence you to 4 years in the prison. Take in consideration night bag number 671041, 671043, 671040, CM number 101289, and Chapter 62 registration, and no contact with minors. Is there anything else from either side with regards to sentencing?
Your Honor, I do have some physical dismissals to present to the court whenever the court's ready. May I approach?
Yes. And did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it, and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, thank you. Thank you so much for coming. Calling 2022 CR 7878, State of Texas versus Augustine Adam. Could I have parties announced for the record for the state?
Now the stakes get much bigger than just prison time. The judge warns that this plea could affect his immigration status, including deportation, naturalization, and his ability to re-enter the United States. Knowing all of that, he still chooses to move forward. But would you make the same decision?
Catherine Pollard.
For the defense?
Charles Button.
I don't think she needs it that slow. Are you Mr. Adam? Defense, I've shown you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Adam, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Adam, I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with the offense of assault, family choking, strangulation, second? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
You believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Adam, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, there's a $750 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
Okay.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 200 hours community service restitution, no contact with Destiny Cardenas, hostility and aggression control course, and no firearms. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then how do you plead to the offenses charged? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Judge. The state would offer what's been marked as State's Exhibit 1.
No objections.
Mr. Adam, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
All right, if we can go off the record for a moment. State, I don't see the 620085 cause number in the stip.
Is that?
That's the case that makes it a second. And so, Mr. Adam, we're back on the record. Mr. Adam, do you understand that the state is adding to their stipulations, and what they're adding to their stipulations is your previous conviction and cause number 620085 on October 8th, 2019. Do you have any objection to that being added?
No, Your Honor.
Defense, any objections? Okay. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments with the addendum of the conviction and cause number 620085, and the court will review the document.
And this is the moment the case reaches a major turning point. The judge finds enough evidence to establish guilt without a jury or live witness testimony. Because the evidence is being presented through stipulations and exhibits, from here the courtroom moves straight into sentencing.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please.
Anything you wish to say on behalf of your client?
Judge, he's been in jail for in excess of 4 months. I believe he's worthy of the plea bargain we ask you to follow.
All right, Mr. Adam, do you have any children?
Yeah.
What are their ages?
7, 6, and 5.
Are these children of Destiny Cardenas?
Yeah.
All right. Well, I'm going to follow the no contact order. Your relationship with her outside of the children is over. And if you have contact with her, it's going to have contact with your children. That's going to have to be through a third party or through the electronic app. Do you understand?
Yes.
Are you employed?
Yeah.
What do you do?
I do contracting. I resurface hardwood floors.
Okay. All right, it's a $750 fine. That'll be probated. There's an affirmative finding of family violence, 4 years deferred adjudication, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with the booster. Court is not requiring you to do that, but if you do that, 40 of your hours will be waived. I'm going to ask for parenting classes. Is Child Protective Services involved?
Yes.
All right, there's going to be parenting classes, CPS compliance and probation. CPS should have parenting classes for him. So if they do, he doesn't have to do it twice. He can do it through CPS.
Your Honor, I did parenting classes with compadre, and I have finished that already.
Well, was that done after this?
Yes. I
Right.
just never got my certificate. I still can go and get my certificate.
Right, you'll have to provide proof of that. The court will give probation, the court will give him credit for that, but only if those classes were done after the date of this offense. All right, so there's to be CPS compliance, no contact with Destiny Cardenas, and probation. If he has completed the parenting classes, then the remaining of the community service hours can be waived. It goes without saying you're not allowed to possess any firearms or ammunition. There's going to be regular reporting by Zoom or in person. There's to be regular UAs, field visits, 1 time per month. And state, is there a reason you're asking for hostility and aggression control course as opposed to BIPP?
No, Judge.
All right, so we're going to do the BIPP course. Probation, is there anything else he needs?
Proof of employment.
Thank you. All right, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Mr. Adam, is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because there's been an affirmative finding of family violence, state, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. We can go off the record. Here's the thing. If you're involved in a relationship with somebody and they come in at 2 a.m., guess what? Everybody's an adult. You have no right to treat them badly. You just have a choice to make. Either you want to stay in the relationship or not. Those are your choices. Your choice is not violence. You understand?
Yes, ma'am.
So before you get into another relationship, you probably need to work on yourself. Well, not probably, you need to work on yourself. All right, good luck to you.
May we be excused?
Yes.
Thank you.
And I'm going to take up this last plea and then we're going to bring the jurors back in.
Wait, his first answer here is no, and that matters. The judge is making sure he actually understands the charges and the rights he is giving up before accepting the plea, and if deferred adjudication is later revoked, the consequences could become far more serious, including a potential sentence of up to 20 years. Here's the key distinction: the court finds sufficient evidence to support guilt, but defers the actual finding of guilt, because the defendant applied for deferred adjudication that gives him an opportunity under supervision. But it also comes with a long list of conditions, and as the judge starts listing them, the seriousness of this deal becomes very clear. The judge ends with a message that goes beyond the legal paperwork. Violence is never the answer. A relationship gives people choices, but it never gives anyone permission to hurt another person. After everything that happened in court, do you think this was the right way for the judge to close the hearing?